So, Maratha Quota law. Okay, that is our first topic. So, what is the context in which we are discussing is the Maharashtra Assembly unanimously passed a bill granting 10% reservation in education and government jobs to the Maratha community. Okay, so this is regarding the Maratha reservation or the reservation which is passed, which is given to the Maratha community in Maharashtra. Okay, and we can see that there is a reservation of 10% in education and also in government jobs. Okay, so regarding this, we are discussing regarding the reservation aspect which is in the India. Okay, law has been formulated after a discussion or after a report which was formulated by Justice Sunil B. Shukre, led Maharashtra State Backward Class Commission. Okay, what was the opinion of the commission is that the commission opinion that the exceptional circumstances and extraordinary situations justify granting reservation to the community beyond the Supreme Court approval of 50% limit. Okay, you have seen about the reservation criteria or reservation which was a major problem or major aspect of discussion during the initial years after the independence, and also later during the 1960s, 70s time also you can see that, right? So reservation majorly, if we talk about reservation, the most important case which is related to reservation is Indira Savni case or Mandal Commission case, right? So Mandal case, okay? Accordingly, the Supreme Court has approved the limit of reservation to be 50%. And also it said that if there is an exceptional circumstances and that extraordinary situations have come, then there's reservation of 50% can be surpassed. Okay. On the basis of this, the Maratha Quota law has appeared. Okay. So if we see, the 52% of reservation is already there in the Maharashtra for backward communities. For example, 7% reservation for scheduled tribes, like scheduled caste and other denotified tribes. Okay, so like that, now 10% have added to those who are in the Maratha community. Okay, so as I said before, regarding the reservation, when we check the reservation as a whole in the country, we can see that the reservation of, as per the existing instructions, the reservation provided to scheduled caste, scheduled tribes and other backward classes are at the rate of 15% for scheduled caste, 7.5% for scheduled type, and 27% for the backward classes. Okay, and this is based on the open competition. Okay, whenever, for example, an entrance test is done, and after that, you will be taking, candidates are taken accordingly from the list, right? So after the open competition, the criteria for reservation is given like 15% is given for scheduled caste, 7.5% is for scheduled tribe, and 27% is for backward classes. Okay, in direct recruitment on all India basis, other than by the open competition, the percentage is fixed as 16.66% for SCs, 7.5% for ST, and also 25.84%. If it is a direct recruitment on the basis of open competition, the reservation is such which we discussed earlier. And if it is not by open competition, then the reservation is as per 16.66% for scheduled caste, and the scheduled tribes, same reservation stays as such. And when we consider the OBCs, the OBC reservation is like 25.8%. Okay. Then, if we see 103 Constitutional Amendment, Amendment Act, which was passed in 2019, it enables that both central and state governments to provide reservation to the economically weaker sections of the society. Accordingly, we have given 10% reservation to the economically weaker sections as well. Remember, this was a recent amendment which was brought to the Constitution. And the amendment was 103rd or 103rd Constitutional Amendment Act of 2019. Okay. Accordingly, the state. Please remember, the state which is in the 103rd Amendment is the state which is defined in the our Constitution. Okay. In our Constitution, if we say, it is not only the state, does not mean only the states as per federalism, right? It includes states, the state includes central government and the state government as well. Okay. So here, accordingly, we can see 103rd Amendment Act of Constitutional Amendment Act of 2019 says that the state, both the central government as well as the state government, has the right to provide reservation for economically weaker sections as well. Economically weaker sections are those who, according to certain criteria which has prescribed by the government, if they are under the criteria, they can be classified as economical weaker sections from the general category. Okay. So we have discussed the economic or the rather the reservation which is provided by for various classes in the country. Now, regarding the EWS, it is decided by the state government for whether the reservation is to be provided or not. Okay. Since 1992 order, several states have passed laws breaching that 50% ceiling, including Haryana, Telangana, Tamil Nadu, Andhra Pradesh, Madhya Pradesh. There are many states which has already breached the 50% criteria, which has held by the Supreme Court on Indira Savani after the Indira Savani case or Mandal case, that the reservation should be maximum of 50%. Okay, but we can see where different countries have already, different states have already breached that. Laws made by many of these states have either stayed or are facing legal challenges. Okay. What are the constitutional provisions which provide or which forms the basis of reservation? Reservation is oftenly the affirmation which we are giving to the weaker sections, right? So we are having the constitutional provisions which justifies the reservation. So accordingly, we can see that Article 16 of the Constitution, Article 16, fundamental rights. Okay. So in article, it comes under Article 14, that right to equality, right? In right to equality as a whole, we can say that the equal opportunities need to be provided. It's regarding the equality of opportunities. But there is a criteria, provides for equality of opportunity for all citizens, but as an exemption, the state can provide for reservation of appointments or posts in favor of any backward class that is not adequately represented in the state services. Okay. We know Article 16 deals with equality in opportunities. And in that, there is an exemption that if the state requires and in the state services, if a community is not represented, then the reservation can be provided in appointments or in post in favor of backward classes. Okay, that is in Article 16. And when you consider Article 16(4)(a), it makes provisions for the promotion, okay, for reservation and promotion in favor of scheduled caste and scheduled tribe if they are not adequately represented in the services under the Act. Okay, these are in the fundamental rights. Then Article 335. Okay, this also suggests that the special measures need to be, or special considerations, and for that special provisions need to be given to the SC and STs. Okay, so it recognizes special measures needed to be adopted for considering the claims of SC, STs to services post in order to bring them at par. Okay. Now, next constitutional provision which we can see is regarding the 103rd Constitutional Amendment Act of 2019, which provides for 10% of reservation for economically weaker sections. Okay, these are the constitutional provisions which suggest or which gives the promotes or supports the reservation aspect in our country. Okay, Article 16, Article 16(4), Article 335, and also the Constitutional Amendment of 103. Now, what are the arguments which are in favor of reservation? Okay, we have the reservation is always a controversial topic or a topic of debate in the country. So what are the arguments which favor or which support that reservation is needed in the country? Okay, firstly, we know that the backward classes, SC, STs, have faced historical injustice. Okay, so as a affirmation to them, or as a as providing them with equal opportunities, or to provide with equality or equity, the reservation is justified. Okay. First argument is caste-based reservations address the root of social injustice and shouldn't be replaced by economic status-based reservations. Okay. So first argument which is favoring the reservation is the reservation is done or needed to be done to address the roots of social injustice which was prevailing in our country during the earlier times. So the caste-based reservation should be more considered compared to the economic status-based reservations which are asked by many people. Okay. Now, the next argument which is in favor is the Constitution mandates realization of substantive equality in the engagement of fundamental rights with the directive principles. Okay. This means that the equality should be provided based or the fundamental rights of the people should be initiated, or the equality. There is a argument that if a reservation is given, then it will hinder the, or it will be a injustice, or it will be contradictory to the fundamental rights. But we can say that the DPSP also we can see the provision should be given to, or certain aspects should be done to get benefit to the backward classes, right? So fundamental in the rights as well as the DPSP should go hand in hand. So accordingly, the reservation can be justified. Okay. The next is, it is stereotypical assumption that the promotions drawn from SCs and STs are not efficient, or that efficiency is reduced by appointing them. Okay. And regarding the reservation regarding the SC and STs in opportunities or jobs and also in appointments, it is said that though the, if without reservation, it cannot be ensured that they are represented for promotion. Okay. So if there is a promotion, then only we can ensure that the SCs and SC and ST community are getting promotion as such. Okay. Now the next is, the main reason for giving reservations and even promotion is that there are very few SC/ST candidates in the higher echelons of government. This is in consequence with the previous statement or previously. Similarly, if we can see that the people who are in the backward classes are often facing problem to come forward in the society. So even in the higher jobs which are in the higher positions as well, they are less represented. So with reservation, they can also come into the higher positions like that of the general community. These are some of the arguments which favor reservation. Okay. Now, there are arguments against that as well. Okay. First is the merit criteria. Okay. If reservation is given, then it will discourage merit and also genuine talent by providing an unfair advantage to the reserved candidates. This is the oftenly discussed demerit or the negative impact which is often pointed out in the country. Okay. So for, as we know, earlier also we discussed that from open competition is considered, if open competition is considered, nearly 50% nearly is given to the backward classes. So oftenly it is discussed that the meritorious students or those who have talent are often discouraged and are often in the disadvantaged position giving after the reservation. Okay. Now the next is, many deem poverty to be eligible for reservation in education and employment over caste-based marginalization. Okay. This is another criteria. Earlier we said that class-based reservation should be given as a solution to the social injustice which were prevailing in our country. But it also, there is a contradictory argument that the economic-based or the wealth-based reservation should be given such that those who are in the general category and also even in general category, those who are facing the poverty can also come forward in the society. Okay. Now the next one is, reservation should only exist to the level playing field initially. They should be discontinued to higher positions or promotions. This is oftenly discussed when we discuss the case of promotion, reservation and promotions. As one of the argument which we saw in favor was reservation in promotions is necessary because only that way the backward communities can be represented in the higher positions. But there is a another argument that the reservation should be used only as an initial stages, that is during the open competition stages in the initial job status. Later, so that there a level playing field is created, and after that in the promotions it should not be considered since it should be meritorious based. Okay. Now this is another argument which is against this. Now the next is economically well-off members of marginalized communities should not avail the benefits of reservation. Okay, this is another, as we said before, caste-based reservation should be replaced by the economy-based reservation. Even after reservation, there are even in the marginalized classes, there are people who are well off in the based on economy, okay, or based on wealth. So it should be ensured that they are not getting the benefit. Rather, those who are economically weaker are getting the benefit. This is another argument which is against the reservation criteria in the country. Next is low cutoffs and eligibility criteria for reserved candidates bring them down the overall caliber of institution or organization. Okay, apart from reservation of seats, we can also see that the cutoff percentage or the cutoff marks which are provided to the reservation communities is less. Okay, so there is an argument that by providing less cutoff, those who are having the real caliber is getting out of the list or out of the place, and those who are scoring the lesser, I mean those who can attain the lesser marks or those who are having the lesser talent are getting into the institution. Thus, over a period of time, the caliber of the institution or the potential of the institution will be getting reduced. This is another argument which is against the reservation. Okay. Now, continued reservation in education and public services were only a temporary measure. So, if we see after there is a when the constitution was formed, there was a reservation for SC, STs and backward class SC, STs for initial 10 years. Okay. Later, if the constitution or the legislature feels necessary, then it can be extended for another 10 years. This was the criteria which was, or this was the clause which was initiated or included in the earlier constitution. But we can see that over the every 10 years, this reservation is increasing. Even recently, during our 101 amendment, we have increased the reservation of SAST category to 10 plus years, right? So, there is an argument that the reservation which was initiated during the earlier years was a temporary criteria only. Okay, this should not be made permanent like that. It should not be renewed every 10 years. Okay, so this is another argument which is against the reservation. Okay, so we have seen the reservation aspects of or the criterias in the country. Then we saw the status of reservation and constitutional provisions which are supporting the reservation. And also we saw the arguments which are in favor of reservation and which are against the reservation, right? So what can be done? Allocating quotas often result in more cases of discrimination and hard feeling towards the communities. Purpose of reservation is not to isolate a particular section, but to make them part of the mainstream society. So, policymakers, while dealing with sensitive matters like reservation policies, must act wisely. So, there should be, it is often recommended that instead of the caste-based reservation, that which is provided, there should be a impact assessment, or the people also should be involved, and voting should also be done. And there is a need for balancing between the caste-based reservation and those who are economically weaker reservations. I mean, economically weaker sessions. There should be a balance between the both. This is oftenly recommended as solutions. Okay? Clear?